On September 4th, U.S. authorities detained about 475 workers in a major immigration raid at Hyundai's EV mega site in Georgia, the largest single site HSI operation to date. Many detainees were reportedly on visitor or waiver entries and accused of working illegally. The story has rattled multinationals and travelers alike. If you're on B-1, B-2, or ESTA, even just sending deliverables from a hotel could be unauthorized employment. I'm Patrick Vendara, and while I'm not an immigration attorney, at Visa Franchise we work with some of the top US firms. This video is for educational purposes only. If you'd like legal advice specifically tailored to your unique circumstances, your case, we'll connect you with one of the attorneys in our network. Today, I'll quickly explain what you can't do on visitor status, the real risk, 2 legal alternatives that actually let you work in the US, E2 and O1, plus where Visa Franchise can support you end to end.
Hey, you want to come to the US, get to E2 visa, L1, or straight out a green card? We've been doing this for the past 10 years, and we wrote a book. It's called Own Your American Dream. What is special about this book is that we went back and have spoken to 21 successful applicants who opened up their businesses here and who are continuing to live the American dream. Hear it from them, because they talk about their fears, their mental state, what went wrong, what went right. The entire blueprint is there. You could just buy the book right here. You can just read it and make up your mind. Continue your video.
US law cares where the work is performed. If you perform services while physically in the US, that's employment, regardless of who pays you or where the bank is. USCIS defines unauthorized employment as any service or labor performed in the US by someone not authorized to work. So what's actually allowed on B1 or ESTA? Think narrow business visitor tasks, consulting with associates, attending meetings or conferences, negotiating contracts, not productive day-to-day work. For ESTA visa waiver specifically, max 90 days and no change of status or extension inside the US, except limited satisfactory departure in emergencies. There is no US digital nomad category today. The 90-day rule, if you engage in conduct inconsistent with your declared purpose within 90 days of entry, consular officers may presume misrepresentation, which can trigger refusals or bars later. Enforcement is real. Beyond removals and bars, employers who hire without authorization face increased civil penalties. 2025 inflation update. Who qualifies? Citizens of a treaty country who invest in and direct a real operating US business. There's no fixed minimum, but the investment must be substantial. Officers use the proportionality test, your committed funds compared to the real cost of buying or launching the business. The venture must be more than marginal, able to support you and ideally create US jobs. Family benefit, spouses of E2s or work authorized incident to status, look for E2s on the I-94. Where Visa Franchise helps, eligibility and strategy, confirm treaty nationality, map budget to the proportionality test, and avoid marginality pitfalls through realistic job creation and revenue plans. Business selection, curated franchise and small business options that fit your investment level and operational profile, plus due diligence to show a bona fide, non-marginal enterprise. We partner with counsel for the legal filings. Evidence package support, business plans, market data, and operational documentation that align with consular expectations on substantiality and viability. Family onboarding, guidance on spouse, 94 E2S, evidence for work authorization. Key reminders, E2 is non-immigrant renewable and tied to your ownership control and the business staying active and real. Who qualifies? People at the top of their field. Business, science, arts, athletics, MPTV. In January 2025, USCIS updated its policy manual to clarify evidence, including examples for critical and emerging tech, helpful for founders, AI tech leaders, and other high-impact profiles. How the job is structured. You can't self-petition, but a US employer or US agent can file. In some cases, a separate US entity you own may be able to petition if it's a distinct petitioner. Consultation letter. Most O1s require a peer group labor organization advisory opinion. We help identify appropriate bodies and synchronize the evidence. Where Visa Franchise helps, O1 audit, we review your awards, press leadership, impact metrics, scholarly work, critical roles, and help build a criteria by criteria evidence roadmap. Founder-friendly structuring, coordinate with counsel on agent itinerary setups to cover multiple projects or clients. Evidence production, we help surface expert letters, media strategies, product impact documentation, map to USCIS's updated 2025 guidance expectations. If you complete services while in the US, that's work. The law focuses on place of performance. No change of status from VWP or ESTA inside the US. At most, satisfactory departure for emergencies. Plan the right visa before you travel. The Hyundai case shows large-scale multi-agency worksite actions do happen and employer fines are up indexed for 2025. If you're considering working from US soil, don't risk visitor status. Talk to our team at Visa Franchise. We'll screen your profile for the E2 and O1, match you with vetted business franchise for the E2, or look to help build evidence for the O1. And of course, coordinate a one-on-one strategy consultation call with a licensed U.S. immigration attorney in our network to work to file the strongest case possible for you. Reach out today and we'll put together the right team to secure the best legal path in the United States for your status.